had a question asked about perspective, which was about the broader issue of determining, is international law really law? So I thought I would record a supplementary video and kind of explain the perspectives a bit more and explain exactly what I'm getting at in that, asking that question. So the question is international law really law? And to answer that question, we really have to go back to a definition of what is the law. What do we mean when we say the law? So when we talk about the law, we have to realize it's not a monolith. It's not some large black book that you can go look up the answers to questions in. Instead, the law is an aggregation of things, an aggregation of statutes and concepts and customs. And it's the same with international law. But when we define international law, to the extent that we can define it, we define it as a system of rules that governs interactions between states. However, there's another aspect to that definition. That definition should be expanded to include a provision saying that the violation of the rules can lead to the imposition of penalties, meaning that there can be a sanction for the failure to obey the system of rules called international law. So when we say, is international law really law, then we have to weigh that against our commonly held notion of the law as a system of rules that includes punishments for violation of the rules. So is international really law? International law really law? Well, we look at it from those three perspectives. Now, the first I said was we look at it from a positivist perspective. You know, you can look at any problem from a different perspective, and you may be able to generate different answers depending on the perspective. If I were to ask a question, if this was a history class, and I said, what were the causes of the American Revolution? Well, you could take that question and answer it from an economic perspective. You could answer it from a social perspective. You could answer it from a political perspective. There are different ways of examining that question, different perspectives, and which perspective you choose could determine the content of your answer. So when I'm talking about perspectives here, I'm really talking about three different ways of examining the problem. And the problem here is international law really law? The first perspective we mentioned was the positivist perspective. Remember, positive law is the command of the sovereign. Positive law is based on the notion that a sovereign gives us the law. So let's answer the question, is international really law, using a positivist perspective? And our answer would really be no, strictly speaking. Why? Because there's no sovereign. There's no international sovereign that is decreeing the law, that is commanding things or forbidding things. There's no sovereign. Nevertheless, we can respond that international law, from a positivist perspective, is the law if, in fact, we argue that state officials, those officials who are subject to the sovereign, if they recognize a law as the law, then it's the same as if a sovereign issued the law. If state officials recognize a rule as the law, then it is the law. Another way of looking at it from a positivist perspective is to contrast it against natural law. Now remember, natural law said that law is basically the same thing as morality, that what's moral should be the law, what's immoral should be against the law, should be outside of the law. Well, we can argue from a positivist perspective that international law is law because it's not tied to morality. It has nothing to do with morality. So international law has many laws that are law, has many features that are law-like, but they are free of morality. International law is not enforced by appeals to someone's conscience, but instead by appeals to the rules, those rules that we recognize as the rules. So that's the positive perspective. Now the next perspective, and the perspective that created the question I'm addressing, was the sovereignty perspective. Now, sovereignty is the power of a state to govern itself, meaning it's the power of a state to govern affairs within its borders. So if we say that there's such a concept as sovereignty and there are sovereign nations, then how is it that we can argue that international law somehow trumps the sovereign interest of a state? So again, from a strict sovereignty perspective, you would argue that international is not law because there's no sovereign to give the command. So how do we recognize this difference? How do we reconcile this difference? Well, we reconcile it by saying that states can consent to international law, and that again, consent by the states to the international law is essentially the same as if a sovereign had decreed the law. If we consent to a law, then, and we consent to be bound by the law, then it's the same as if a sovereign, and we define sovereign by saying it's the person, the entity, or the thing that is used to being obeyed, that's in the habit of being obeyed. It's the thing that's obeyed. Well, if the thing that is obeyed consents to an international law, then it's just as if a sovereign entity decreed that law, commanded something or forbid something in the law. Now, the final perspective of answering this question, is international law really law? We look at it from the enforcement perspective. Now, the easy response to this is international law is not law because there is no legal system to enforce the law. Remember, when we define law, we say it's a system of rules, the violation of which can be punished. Well, from an enforcement perspective, there is no body that can punish, no entity that can punish people who transgress against the rules. So one would argue from an enforcement perspective, international law is not law. There's no executive to enforce the law. There's no legislature to create the law. There's no judiciary, no binding judiciary, in that the International Court of Justice in The Hague can only hear those disputes if the parties agree that the court's decision is binding. Now, from an enforcement perspective, the reason why enforcement is perspective goes back to that original definition of the law, that the violation of a system of rules can lead to an imposition. And as I explained in the previous video, for every right, there is a remedy. There are these two aspects of the law. There's a right created by the law, and there's a means to enforce it. However, from an enforcement perspective, again, we can argue that consent to enforcement and consent to a quasi-legal system is enough to establish the enforcement of international law. So, although there is no legislature, no international legislature, we do have the General Assembly and the Security Council of the United Nations, which we'll visit in the next lecture. We have the principles of customary international law, which we will talk about in the next lecture, which are carry as much weight as treaties, maybe even more weight than treaties. We have treaties, which act as contractual law. We have large-scale treaties that govern what parties can do or not do. And we have a judiciary. We have the International Court of Justice and its various tribunals, which the parties can agree to be bound by. So enforcement of international law is not completely lacking. We have instruments. Now, they are ill-formed, they are ambiguous. Nevertheless, we can argue that even from an enforcement perspective, international law is the law.